Section 23 of Tribal Custom in Anglo-Saxon Law. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Read by Claire. Tribal Custom in Anglo-Saxon Law by Frederic Seebohm. Chapter 9. Tribal Custom in Scotland, Part 1. Traces of tribal custom in the laws of the early kings. The population of Scotland was so various in origin and language that it would be unreasonable to expect uniformity of custom. Even when Celtic custom was best able to hold its own, there must naturally have been a mixture of Cymric and Gaelic elements. In districts, on the other hand, where Frisian and Northumbrian and Danish and Norse influences may have once predominated, whatever survivals there may have been of tribal custom from any of these origins may well have been afterwards submerged under legal forms and ideas from Anglo-Norman sources. It is worthwhile, however, to examine what scattered survivals of tribal custom may be found in the laws of the early kings, and in the various documents collected in the first volume of the Ancient Laws of Scotland. That tribal custom as to wergild existed and was recognized is proved by the necessity to abolish what remained of it. Thus, in the Liege Quatuor Burgorum is the following clause: 17. Of Bludwit and Cyclic Thingis. And it is to wit at in Burg sal nacht be heard Bluwit na yit, Stingigent, na merchant, na hergild, na noon, sulik manner of thing. This wholesale and disdainful disregard of feudal and tribal customs on the part of the townsmen of the four burghs was followed somewhat later by an ordinance of Edward I, A.D. 1305, which again testifies to the wider survival of more directly Celtic tribal usages by forbidding their continuance. Ordene est que les usages des Scots et des Brits de Sorendroit soit defendu si que mesne soyent uses. Here we have the usages of the Brets and Scots distinctly recognized as still lingering on so late as the beginning of the 14th century in some parts of Scotland. In the laws of King David there are distinct traces of ancient custom as regards wergilds and the connection of the kindred with their payment and receipt. In section 14 it is enacted: If in any place within the peace of the king any one shall attempt to strike another, he shall pay to the king 4 cows and to the other 1 cow. If he shall really strike, but without drawing blood, 6 cows to the king and 2 cows to the other. If blood be drawn, 9 cows to the king and 3 to the person struck. If he slays the other, he shall give the king 19 key and a kolpendak, huvenka, and he shall assess to the kin of him slain after the assess of the land. Clause 15 deals with violence done in the king's court. If anyone draws a knife to another in the king's court, it shall be stricken through the middle of his hand. If he draws blood, the hand shall be cut off. And if he slay any man, he shall give to the king 20 key and a kolpendench, and he shall make peace with the kin of him slain and with the kings after the assire of the kinrick. In both these clauses, the wergild to the kin is additional to the payment to the king of 180 cows for breach of his peace. Clause 16 forbids the letting off of a thief for money or friendship. An earl or anyone having the freedom and custom of an earl who does that is to pay the king 100 cows, and other great men not of earl's rank 34 cows. The thief is to be outlawed through all the king's land. It is clear, then, that in the time of King David, the system of wergilds payable to the kindred of the person slain was generally in force, though no amount is mentioned, and that payments were made at this date mostly in cows. In the Assize of King William, under date A.D. 1180, is the following mention of the wergild, to be paid evidently for a thief who has been allowed to escape as above. 14. Of the law which is called wergild. Of every thief through all Scotland, whether that he be bondman or freeman, the wergild is 34 kye and a half. The following clause is further evidence of the continued right of vengeance on the part of the kin of a person slain. 15. Of a man slain in the king's vengeance. If any one for theft or rapine dies by law of iron or water, and of him right be done, or if he were slain with theft found with him, and afterwards, if his kin in vengeance of him slew him that brought him to the law, the king shall have as fully right of such men slayers for the death of him, as of his peace fully broken, without concord or relaxation, unless it be through the counsel or the assent of his kin. And if it happen by chance that the king grant peace to the adverse party, unknown to the kin of him that was slain, nevertheless the kin of him shall take vengeance of them that slew their kin. Among the statutes of Alexander II, under date A.D. 1220, the following fines were imposed upon persons who held land of the king and who absented themselves from the army. Clause 2, page 68. From a thane, 6 cows and a gillet, juvenka. From an octern, 15 sheep or 6 shillings, half to king and half to the thane or the knight. From a carle, rusticus, a cow and a sheep to be divided between the king and the thane or knight, but if with the leave of the thane or the knight, then all to the king. This clause reveals a social division of classes into thanes, octerns, and carles or rustics, to which another clause, 4 A.D. 1230, enables us to add the nativus or kind-born bondman. It is not needful to pursue the inquiry into the laws of the later kings of Scotland, but among the fragmenta in Appendix 5, page 375 of the collection, there is one which must not be overlooked, although it may be difficult to fix its date. It seems to be made up of 2 fragments united, and is interesting as containing 2 very different statements of the payment for the life of a man. Put into modern English, the first part is as follows. All laws either are man's law or God's law. By the law of God, a head for a head, a hand for a hand, an eye for an eye, a foot for a foot. By the law of man, for the life of a man, 9 cows, for a foot a mark, for a hand as much, for an eye half a mark, for an ear as much, for a tooth 12 pence, for each inch of length of the wound 12 pence, for each inch of breadth of the wound 12 pence, for a stroke under the ear 16 pence, for a stroke with a staff 8 pence, and if he fall with the stroke 16 pence. For a wound in the face he shall give an image of gold, a coin with the king's head upon it. The other part is as follows. And by man's law for breaking of bones 5 oars, for a wound under the clothes 12 pence, for a wound before the sleeve 16 pence, and for each visible wound except the face 15 pence. For a man's life 12 marks, for a wound above the chest 6 solidi, and under the chest 60 pence, for a foot stroke 60 pence, for blood drawn 25 shillings, and beyond the sea 6 cows. Now what are we to make of these fragmenta? Clearly the 2 fragments must be taken separately, for in the first the payment for the life of a man is 180 cows, and in the second the payment for a man's life is 12 marks. Mr. Robertson seems to have concluded that the payment of 180 cows was the wergeld according to the assize of Scotland, or as he puts it, the man-boat for homicide throughout Scotia. But he arrived at this conclusion apparently by connecting this fragment with the clause already quoted in the assize of King David, which states that a person killing another in any place within the king's peace shall pay to the king 180 cows and a colpendach. He concluded that the payment was 180 cows from the reading 9 cows, as it is found in the Eyre manuscript of one of the clauses, as already stated. But the clause itself shows that this payment to the king was not the wergeld, because after making this payment the slayer had still to assize to the king of him slain after the assize of the land. Nor does it seem any more likely that the payment of 12 marks mentioned in the second fragment was the wergeld of Scottish custom. From its amount it seems much more likely to correspond with the payment already alluded to as the wergeld of the thief allowed to escape, which, however, might possibly represent that of persons of lowest rank. The evidence of these undated fragments leaves us in the dark as to what the wergeld of the ancient assize of Scotland may have been. Confused and mixed statements as to the wergelds are not surprising when the mixture of races is taken into account, and, after all, the phrase after the assize of the land, or after the assize of the Kynric, may refer only to those portions of the kingdom to which the laws of King David specifically applied. 2. The regime majestatum. Further traces of tribal custom are mentioned in the treatise entitled Regime Majestatum, apart from the remarkable addition to it, which also appears again as a separate document under the heading Leges inter Bretos y Scatos. The Regime Majestatum itself may be regarded as a version of Glanville's well-known treatise on English law, applied with alterations and adaptations to Scotland by a Scotch writer conversant with local custom, and probably dating between AD 1200 and 1230. As in the laws of King David and his successors, so in the body of this treatise, references to ancient usages occur with occasional survivals of untranslated Gaelic words which seem to refer them back to Celtic tribal custom. Thus, in Lib 2, Section 9, in reference to the modes by which nativi might obtain freedom, a specially Scotch addition is made to the effect that if a lord has carnal intercourse with the betrothed wife of his service, and this is proved by the vicinages, the service is thereupon released from the servitude of his lord. And then follows the phrase, nec aliud inash habit ad domino sunisi recuperatium libertas. This untranslated Gaelic word, inash, has already been met with the enech lan of the Irish honour price, and we shall find it used again when we come to the customs of the Brets and Scots. So in Lib 4, Chapter 7, in cases of rape of the woman, according to the text of Glanville, is to make it known to men in good position, probi homines, or to the propositus of the 100. In this Scotch treatise, the writer inserts, instead of the words propositus of the 100, vice comitatus vel le tash iterach. The Gaelic toshach, or chieftain of a district, is much in evidence in the marginal records of the Book of Deer. Again in 4:12 is a passage not found in Glanville. The theft of a calf or ram, or whatever can be carried off on the back, is described in the local words, Berthinsac, Seu, Ibernanathanseca. In the same chapter is inserted the already quoted clause from the Assize of King William as to the weirgeld of a thief who has been allowed to escape. De uno quoque fuere per totem, scoxium es weirgeld, triginta vacae et una juvenca, sive fuerit liber sive servus. In 4:23, a pledge is mentioned quod vocator colrach. In 4:30 of the treatise it is stated that if a person on horseback rides over someone going before him so as to kill him, he must render for the dead man so killed, crow et galnes, as if he killed him with his own hands. And it goes on to say that if the rider treads a man to death by riding over him when backing his horse, as it would not then presumably be his fault, he is to pay nothing but the 4th foot of the horse, which satisfaction the parentes of the man killed ought to accept. The mention in this treatise of crow and galnes payable to parentes of the slain seems to imply that the customs relating to payments for homicide were generally enforced throughout Scotland and not confined to any particular district. The words crow and galnes, apparently meaning the weirgeld, meet us again in the document relating to the customs of the Brets and Scots. The final clause, 4:54, describes the merchet of women according to the Assize of Scotland. It begins by stating that the merchet of a woman, quecunque mulier fuerit, sive nublius, sive serva, sive mercenaria, is una juvenca vel tres solidi, with 3d as rectum servientis. Surely a female slave is here intended. This seems to be the minimum merchet, for the clause proceeds, and if she be the daughter of a freeman and not of the lord of the town, dominus villae, her merchet shall be 1 cow or 6 shillings and rectum servientis, 6 pennies. Likewise the merchet of the daughter of a thane's son, or ochatherin, 2 cows or 12 shillings and rectum servientis, 12d. Likewise the merchet of the daughter of an earl, comes, and that of a queen, 12 cows and rectum servientis, 2 solidi. This clause regarding the merchet is useful as giving a scale of values in cows and shillings. Juvenca equals 3 shillings, cow equals 6 shillings, and the merchet scale. Equation: mulier, nobilis serva or mercenaria, throughout Scotland, half cow. Daughter of a liber, 1 cow. Daughter of a thane's son or ochatherin, 2 cows. Daughter of an earl or of a queen, 12 cows. End equation. The solidus of this document can hardly be any other than the Anglo-Norman silver shilling of 12 pence of 32 wheat grains, i.e. 384 Wg. The cow equaled 6 of these shillings, or 2,304 Wg. At the Anglo-Norman ratio of 1 to 12, the value of the cow would thus be 192 wheat grains. That is exactly the normal ox unit of 2 gold solidi of imperial standard. This curious result is not only interesting as one more instance of the tenacity of custom in retaining the traditional gold value of the animal used as the unit of payments when mating cattle, but also useful for our present purpose as affording a valuable proof that the Scotch compiler of the Regime Majestatum, in appending the important clauses relating to the customs of the Brets and Scots which follow closely upon this merchant clause, was added to his work a quite independent document, probably of much earlier date. In this added document, while the payments are again stated in cows, the value of the cow is reckoned not in shillings but in ores, which the figures, when examined, show to be ores of 16 pence. This reckoning in ores of 16 pence suggests a Norse or Danish influence, for although the Anglo-Norman reckoning in shillings of 12 pence ultimately conquered and became the prevalent reckoning in Scotch statutes, there was no doubt a period when the reckoning in ores of 16 pence was in use in Danish England, probably including Northumbria. This is shown by a law, probably of Canute's, which enacted as follows: Et ipsi qui portus custodiant efficient per overhearsenum meum et omne pondus sit marcatum ad pondus quo pecunia me recipitur, et eorum singularum signator ita quod 15 ora librum faciant. Those who have charge of the towns, portus, shall secure that under penalties every weight shall be marked at the weight by which my money is received, and let each of them be marked so that 15 ores shall make a pound. The ores of this law, as we shall see, were evidently ores of 16 pence, or 512 wheat grains, 16 times 32, for 15 of such ores made the Saxon and Anglo-Norman pound of 240 pence, or 7,680 wheat grains. The fact that the ore of the document describing the customs of the Brets and Scots was the same ore as that in use with both Danes and English in Danish England, and probably Northumbria about AD 1000, is an important one. For in this document the value of the cow of the Brets and Scots is stated to be 3 ores, i.e. 1,536 wheat grains of silver, and at the Scandinavian ratio of 1 to 8, the gold value of the cow would therefore be once more 192 wheat grains, or 2 gold solidi, of imperial standard. That the Danish ratio was 1 to 8, as in the Scandinavian laws, we shall find to be involved in the Anglo-Danish compacts, making Danes and English equally dear, while as late as AD 1192, the Abbey of Kelso compounded for payments to the Pope at the same ratio, 2 solidi of sterlings, 24 pennies of 32 wheat grains, or 768 wheat grains of silver being paid for the gold solidus of 96 wheat grains. We may therefore consider that the document relating to the Brets and Scots belongs to the period of Danish influence, and is of much earlier date than the work to which it was appended by the Scotch editor of Glanville. End of section 23.